families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to this week's episode of Families Divided TV. Constitutional issues are seldom raised in family court. There's a good reason for that. They are unlikely to be seriously considered by the court. But that doesn't mean that constitutional issues aren't relevant to family law. There is now more than a century of Supreme Court decisions holding that parental rights are fundamental constitutional rights. The phrase fundamental constitutional rights is not just lofty, but empty rhetoric. It has a very specific legal meaning and should have important implications for how courts handle custody disputes between parents. Fundamental constitutional rights may not be interfered with by the state unless there is a compelling state interest to be achieved by doing so. And when there is such an interest, the state must proceed in a manner that involves the least serious infringement on those rights. The implications of the doctrine that parental rights are fundamental constitutional rights are significant, and they constitute an indictment of the way courts routinely address issues of child custody in divorce cases. There is, Dr. Don Hubin will argue tonight in this episode, a constitutional right to a presumption of shared parenting when parents divorce. Despite this, Dr. Hubin cautions parents not to rely on this constitutional argument in seeking to retain custody of their children when they divorce. This will be a great episode. I hope that you all have pen and paper. You're going to want to be able to take notes. Dr. Hubin's got a vast amount of information in this episode. We're also going to be hearing from Dr. William Burnett. He will be joining us at our fall conference, October 13th through the 15th, Alienation, the Truth Regarding the Trauma and the Abuse. This conference will be a virtual international conference. People are registering from all over the world, and we're really happy about that. This is not a conference just for alienated family members. By far, it's not. It's also very important for professionals to attend. As a matter of fact, if you are a professional or if you have an organization, we are now not going to be doing sponsors this year like we normally do. We're offering you the opportunity to do a networking on Saturday night from 7 to 8 p.m. of the conference. And we're also going to do a web page to advertise for you free of charge, whatever you wish to have on that page as soon as you want to get it to me. So please take advantage of this. It's no extra charge. You just have to pay for your registration, and that's all. So we hope that you'll take advantage of this because people really need to know about organizations that they can go to, support groups, and also, very importantly, professionals that do understand alienation. So we're trying to help in every way we can. So we hope you'll go ahead and register. It's going to be running from 7 p.m. Friday night till 10 p.m. Sunday night straight through. Much going on, many events, many things special just for you. So please join us. We look forward to that. We're going to be back with Dr. Don Hubin and Dr. William Burnett right after these messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Sadly, too many know the pain and trauma associated with parental and grandparent alienation. Family Access, Fighting for Children's Rights, will present an important international virtual conference on October the 13th through the 15th, 2023. The conference, entitled Alienation, The Truth Regarding the Trauma and Abuse, will feature world-renowned experts in the field of alienation. You'll join the conference event coordinator, Elaine Cobb, and moderator, Megan Hunter, as they introduce you to keynote speaker, Dr. Edward Kruk. Plus, you'll hear important presentations from Dr. Joshua Coleman, Lisa Rothfuss, Dr. Mary Alvarez, Chris Smith, Bill Eddy, Dr. Noel Hunter, Dr. Sue Kornblum, Dr. William Burnett, Megan Hunter, and Jordan Traeger. Join the many attendees already securing their spot for the conference entitled Alienation, The Truth Regarding the Trauma and Abuse. For information, visit familyaccess.info for all the details. This special conference is being hosted by Family Access, Fighting for Children's Rights, Steel Partners Foundation, and PASCA, Parental Alienation is Child Abuse.
Hi, as Elaine mentioned, I'm Don Hubin, Chair of National Parents Organization. I want to talk today about something that has been close to my heart for many years. I am a now retired professor of philosophy at The Ohio State University. And when I went through the family court system, I started thinking about it professionally. I started thinking about it in terms of the issues that I raise when I teach philosophy of law courses and teach about what constitutional rights are. So the topic for today is the Constitution and child custody. And I want to start with a sort of thought experiment. So if you'll bear with me here, I want you to imagine a right that people have. And imagine that this right is a fundamental right protected by the First, Fifth, Ninth, and 14th Amendments. And then imagine that it is a right that is far more precious than property rights, that it's an essential right, protecting essential interests, substantial interests, that undeniably warrants deference and, absent a powerful countervailing interest, protection. And finally, that it's a right that cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all of our civic and political institutions. Now, you got that? Now, imagine that our legal system actively functions to suspend or to deny that right hundreds of thousands of times a year. Imagine also that this is done under the color of state law, and that it's done on the basis of little or no evidence, without any indication that retention of the right would be harmful to any person. Okay, now what would or what should our reaction be to this? Outrage? And I think the answer is indeed. But of course, you might say, well, there isn't any such right like that that's so fundamental and is systematically violated by our courts. But I think there is such a right. And the right in question is the right to the custody of one's child, the cluster of rights, really, that are labeled parental rights. Now, this might sound like hyperbole, might sound like exaggeration, but I don't think it is. My claim is that states routinely violate parents' fundamental constitutional rights in the context of determining child custody in divorce cases. Now, first, I want to be clear, there is a context in which the states are very careful to protect parental rights. That's the context of termination of parental rights. So there's a large difference between how courts handle judgments about terminating a parent's rights and how they handle judgments about child custody following divorce. In the case of the termination of parental rights, the courts do require that there be clear and convincing evidence that there's a compelling state interest at stake, that the retention of those parental rights would be seriously harmful to the children. But in deciding child custody following a divorce, courts routinely deprive one parent of parental rights without any showing that this is necessary to achieve a compelling state interest, without any showing that this is something that's important for protecting the well-being of children. So my thesis, remember, is that states routinely violate fundamental constitutional rights in the context of determining custody following divorce. Well, I told you I'm a retired philosophy professor, and our stock in trade is arguments. So here's my argument. Parental rights are fundamental constitutional rights. That's the first premise. Second, it's a violation of the US Constitution for a state to interfere with fundamental constitutional rights unless doing so is necessary to achieve a compelling state interest that can't be achieved in any less constitutionally offensive way. That's a mouthful, but the point is simply that you're not allowed to infringe on fundamental constitutional rights unless it's really necessary for the state to do so, and there's no other way for them to achieve this important state interest without violating those rights. The third premise is that in determining the constitutional rights of divorcing parents, states routinely suspend or deny parental rights without any serious evidence that this is necessary to achieve a compelling state interest. And the conclusion then is my thesis. In determining the custodial rights of divorcing parents, state courts routinely violate the US Constitution. Okay, well, what are these parental rights that we talk about? Well, here's a list. This is a pretty standard list of parental rights. It's not intended to be exhaustive. There may be other things that we want to add to it, but these are some of the core rights that we think constitute parental rights. The right to physical possession of the child. The right to inculcate the child in one's own moral and ethical standards, including the right to discipline the child. The right to control and manage the minor child's earnings and property. And if your children are like mine, they didn't have any earnings or property for you to control. The right to have the child bear the parent's name. The right to prevent adoption of the child without the parent's consent. The right to make decisions concerning the medical treatment, education, religious training, and other activities of the minor child. And finally, the right to the information necessary to exercise the above rights responsibly. So that's a cluster of rights that we think are part of what it is to have parental rights over a child. It's important to say that parental rights are natural rights. And what I mean by that is they aren't creations of the state, like the right to have a driver's license. That's something the state creates, that the government creates. Parental rights are natural rights. They're rights that are recognized by the state. They pre-exist the state. They exist independently of the state. They're not created by the state. It's also important to say that parental rights are fiduciary rights. And if you've been watching TV when financial advisors are giving you advice, they will often tout the fact that they are fiduciaries. And what that means is these financial advisors have a responsibility to act in your best interest. And similarly, parental rights are the rights that parents have over their children to act in the best interest of the children, and they have a moral duty to do so. So it's not like the rights you exercise over physical property. They're rights that exist precisely so that you can benefit the children. It's also important to say that parental rights are not absolute. A parent's right to determine the education of their child may be overridden by the need to provide the child with an education necessary to have a full life. If there's a parent that decides that they're not going to educate their children at all, they're not going to teach them to read and write or how the world works and so forth, that's to exercise something that is beyond the parent's rights, because remember, the parent's rights are fiduciary. They're to promote the best interests of the children. But though they're not absolute, they are strong rights. They can be overridden only when there's a serious countervailing moral consideration. They're also not unlimited. And this distinction between unlimited and absolute is kind of an abstract philosophical distinction, but I already warned you, I'm a philosopher. The The idea here is that some rights that some things that you might think a parent might have a right to do, it's not just that they're overridden by some countervailing consideration, it's that they don't exist at all. So a parent doesn't have any right at all, not just an overridden right, to discipline the parent's child using physical torture. So that's a little bit about the content of the rights I mentioned before, and a little bit about the nature of the rights. Now, remember I said that parental rights are fundamental constitutional rights. Are they? Well, I'm going to rely on what lawyers call a doctrinal argument. And all they mean by that is they're relying on the claims that have been asserted by the US Supreme Court, which is the ultimate arbiter of the law in the United States. And so those quotes that I started off this talk with, those are all quotes from US Supreme Court decisions talking about the nature of parental rights. So to remind you those quotes, one decision, the Supreme Court said that parental rights or the right to parent one's children is a fundamental right protected by the First, Fifth, Ninth, and 14th Amendments. In another decision, they said it is a far more precious right than property rights. They also said that it's an essential right and that it undeniably warrants deference and absent a powerful countervailing interest protection. And finally, that it cannot be denied without violating those fundamental principles of liberty and justice, which lie at the base of all of our civil and political institutions. So remember, the first premise of my argument is that parental rights are fundamental constitutional rights. That's something the US Supreme Court has been saying for over a century. What about this state interest in interfering with parental rights? Remember, even fundamental constitutional rights can be interfered with if there's a compelling state interest for doing so. Well, the state's interest in the custody of children arises from a doctrine called parens patriae. Literally, it means that the state, the government is the parent of the state. But what it means in practice is that the government has an interest in functioning as a legal protector of citizens who are unable to protect themselves. So that would be children or maybe adults who have some disability or something. Under this doctrine, the state can protect their interests. And there are few who would deny that the government has such an interest in protecting children from harm. That's the basis for laws against child abuse and so forth. So the state does have an interest in this. In describing the state's interest in the well-being of children and the termination of custody cases, researcher Josephine Fior says, the right of parents to raise their children is fundamental and falls within the liberty interest defined by the Fifth and 14th Amendments. The parents' interests concerning the upbringing of their children are entitled to constitutional protection. Due process protections are invoked when governmental action threatens parents' rights to the custody of their children. Parents may not be deprived of the right to raise their children absent a strong governmental interest. The state, as parens patriae, has an interest in the welfare of its children. The state's interest, however, is secondary to the parents' interest. The state may intervene only if the parents fail in their responsibility to care for their children. So that's the way parental rights are treated when we talk about termination of parental rights. How are they treated when we talk about custody? Well, typically, temporary custody is awarded based on unchallenged affidavits or a cursory hearing before the court. And typically, permanent custody is awarded based on the court's judgment about what is in the best interest of the child. In neither case is there a showing by clear and convincing evidence that the award of custody is necessary to achieve the compelling state interest in protecting children from harm. Now, you notice that I put quotes around, and when I spoke, I put air quotes around the word awarded in talking about an award of custody. Why is that? Well, the phrase an award of custody is a bizarre twist of language. It conceals the true nature of what's happening. When parents are married, each parent has parental rights. When they walk into the courtroom, Both parents have parental rights. When an award of custody is made in a divorce proceeding, no one has been awarded anything that they didn't previously have. When an award of sole custody is made in a divorce proceeding, one parent has been deprived of the rights they previously had. So we should not call it an award of custody. We should call it a deprivation of custody. It's not as if custody of the children belongs to the state and they are graciously giving it to one of the adults making an award. What's happening in a custody decision is that one of the parents is losing parental rights that parent previously had, at least if the parents were married. In a non-marital case, things are more complicated. So this is a deprivation of a fundamental right, and it's occurred without any showing that it's necessary to achieve a compelling state interest. These are not the arguments over custody of children, especially in the temporary orders period, but even in the final orders period, are not arguments that the deprivation of custody rights of one of the parents is necessary in order to protect the children from harm. So what are the implications of this? Well, one implication is that there is a constitutionally mandated, strong legal presumption in favor of shared parenting when parents divorce. Overcoming that presumption requires a showing by clear and convincing evidence that there's a compelling state interest at stake that can be achieved only by denying shared parenting. This is what I call the constitutional argument for shared parenting. The constitutional argument for shared parenting is sound. I say that because I have been a defender of the constitutional argument for shared parenting since I published a paper defending it back in 1999 in the Journal of Law and Family Studies. Other researchers have also come to the same conclusion, that the Constitution actually requires joint custody. That obviously raises a question in many people's minds. If this is a constitutional right that we have, does this provide a lever for parents to use in their custody disputes? And I get questions about this all the time. And I have people asking me if I will testify in court to defend their plea for shared parenting before the court. And my answer is always and consistently no. The constitutional argument for shared parenting is not a lever for one to use in court. I always discourage people from relying on the constitutional argument for shared parenting. Why is that? Well, for most family law attorneys and judges, constitutional law is just a course they had to take in law school. It's not something they take seriously in their courts. And I actually have a cartoon that illustrates this. Not sure if you can read it, but it says, "I'm sorry, Mr. Campoverde. It sounded like you said you're basing your case on your legal rights as a father," and all of the court officials are laughing at that. I don't think courts will actually laugh at it, but it is my experience that the courts will not make their decision based on a constitutional argument. And so I urge people in custody disputes, always rely on arguments about the best interest of the children. So let me remind you now that we have more than 40 years of research that shows that in the vast majority of cases, children do best when they're raised by both of their parents after a divorce or separation, when both parents are fully engaged with the children and have substantially equal parenting time with the children. That's the argument that is successful in court. That's the argument that one has to rely on, not the constitutional argument. We could wish that it were otherwise, but it's not. And so while I think that the constitutional argument for shared parenting is an excellent argument to make and defend in law schools and in graduate seminars, and I've done that, I don't think that it's an excellent argument to rely on in family law court. Your first responsibility as a parent is to ensure that you have the best relationship with your child that you can have so that your child will flourish, not to win some abstract philosophical point. And perhaps it's embarrassing for a philosopher to say, put the philosophy aside and focus on what's going to bring about the best result for your child. But in addition to being a philosophy professor, I'm also a father. And I would urge you to put aside the abstract argument, leave that for arguments about legislation in family court. Make the argument that it's in the best interest of your children for you to have shared parenting. Thank you. I'd like to say a little bit about National Parents Organization, why I'm spending my retirement years working really almost as a full-time unpaid job with National Parents Organization. National Parents Organization is the largest and most effective shared parenting organization in the country. I have been saying for several months, we have chapters in 27 states. I think we now have chapters in 28. I just met with some representative from Alabama, and we are going to start an NPO chapter in Alabama. We are working to reform the norms of separated parenting to ensure that parental separation doesn't lead to parental deprivation. And the reason we're doing this is that the research shows that the harms that are experienced by children whose parents separate are largely the result of parental deprivation, not parental separation. And what I mean by that is this. The research shows that on virtually every metric of child well-being, children raised in an equal shared parenting arrangement by separated parents do about as well as children in intact marriages, and they do much better than children who are raised in a sole custody arrangement. So NPO is working to reform those norms. We are working to change laws, but changing laws is only part of our task. We really want to change the hearts and minds of people. We would like to educate judges about the benefits of equal shared parenting, attorneys, psychologists, custody evaluators, guardians ad litem, and so forth. And we want to educate parents about the benefits of equal shared parenting, because there's no country and there's no state in the country where if both parents go in and say, we are not going to live together anymore, but we want to raise our kids together because we know that's best for them. There's no state that's going to say to them, no, you can't do that. So it's a multifaceted task to educate people about the benefits of shared parenting, to change the laws in order to reestablish the norms of separated parenting. We've done polling in 25 states now that show that this is overwhelmingly supported by the public. And when I say overwhelmingly, the number of the percent of people who support equal shared parenting presumptions is above 75% in every state that we've polled, and we polled half of the states now. This is true in blue states, it's true in red states. And when you dig down beyond the overall numbers, you see that it cuts across every demographic divide. It doesn't matter people's race, ethnicity, religion, political affiliation, sex, it doesn't matter. People support equal shared parenting. The research supports equal shared parenting. What's taken time is to get the legislature and the courts to move on away from this 1950s model of separated parenting, where one parent is the primary parent and the other parent visits the children on alternate weekends and possibly on a weeknight for dinner. Move it to something that's more appropriate for the 21st century, where parents are sharing both the responsibilities for supporting a family financially more equally and sharing the responsibilities for raising the children more equally. So if shared parenting is something that matters to you, if you think this is an important goal, then I urge you to join NPO and help us reform the norms of separated parenting.
Hello, I'm Dr. William Burnett. I'm a child psychiatrist and forensic psychiatrist in Nashville, Tennessee. I'm looking forward to the virtual international conference that will occur in October 2023. As you know, this conference is created by the organization Family Access, Fighting for Children's Rights. This conference has an interesting title, Alienation, the Truth Regarding the Trauma and Abuse. My own presentation is also somewhat provocative. It's called Truth or Dare, Strategies for Addressing the Epidemic of Parental Alienation Misinformation. One of the unusual aspects of parental alienation theory and practice is the huge amount of misinformation and outright false information that has been published regarding this topic. Over several years, I have documented parental alienation misinformation that was found in peer-reviewed journals, presentations at conferences for mental health and legal professionals, in books edited by psychologists and attorneys, in official statements by professional organizations, and even misinformation in a resolution before the United States Congress. It is impossible to spread the truth about alienation without identifying and counteracting the false and misleading information that is so widespread. In my presentation for the Family Access Conference, I will tell you about several specific examples of misinformation and also our attempts to challenge and correct these false statements. Most of these attempts to set the record straight regarding alienation have been successful. A few have not been successful, and perhaps we can learn something from both outcomes. I'm hoping that the listeners of my presentation at the conference will think about ways they can identify and fight the epidemic of parental alienation misinformation. I hope to see you then. Thank you for your interest in this important topic.
Next week on Families Divided, we will hear from Dr. Noelle Hunter on surviving parental abduction and parental alienation.